Yeah, so good morning. My name is Renee Burek, and I am from Immigration Law Associates in Skokie. Put down the list, yeah.
Good morning. I'm Alexandra Lopez. I am the managing partner of Cunningham Lopez LLP, and we are located here downtown Chicago in the Loop.
Hi, my name is Hugo Rojas. I'm an immigration attorney as well. That's why I'm on this panel. And I'm with Scott Pollock and Associates. It's an immigration law firm just down the street, 2 blocks that way.
So we're going to get started today by talking to you a little bit about maintaining your status, your F1 status, and how important that is. Given that the current administration is really focused on enforcement, it's really more critical than ever for you to maintain your F1 status. You may be thinking, I have a valid I-20. Isn't that all I need to maintain my F1 status? Well, no. USCIS is going to be looking at a lot more than just your I-20 to determine whether you have maintained your status. They will be scrutinizing pretty much every F1-related document that you have, and they will be doing that when you apply for any kind of a benefit. If you apply for OPT, if you apply for a change of status, if you're applying for a green card based on employment, if you travel, any chance that they get, they will be reviewing whether you have maintained your status. So some of the things that they're looking at is, did you engage in unauthorized employment? Did you drop below full-time status when you were not authorized to do so? Did you take too many online courses or skip classes? Did you, engage in OPT employment that wasn't related to your field of study? They're very tough also on CPT, and they want to make sure that you have complied with all of the relevant regulations, and a myriad of a lot of other things that they could be looking at to see whether you have maintained your status. So there are a couple things that you can do that are fairly simple to make sure that you avoid violations and that you maintain your status. And the first one that I think is kind of a golden rule for students is to ask before you act. That means that before you decide to change anything about your F1 status, you first talk to your DSO. It doesn't matter how small the change may seem to you, how trivial it is. You should always talk to your DSO to make sure that it's allowed and to know what steps you have to take to effectuate that change. So whether it's something significant like dropping a class or engaging in employment, if you want to travel abroad, if you want to take a break from school, or even something as small as changing your address or changing your CPT hours from 15 to 20. Make sure that you're always talking to your DSO first before you take any of those steps. Also, if you don't get all of the answers from the DSO or you have a more complicated issue, schedule an appointment to talk to an immigration attorney before you do anything. It doesn't take a lot of time. It may be just an hour that you need, but it's important that you discuss taking any changes before you actually do them. So ask before you act. It's probably one of the most important things you can do to protect your status. Because immigration isn't going to take an excuse, well, I just didn't know, I didn't realize, I wasn't sure. Well, you should have asked, and that's what they're going to say. You should have asked, and you're still responsible for that violation, even if it wasn't done in a bad intention. The second thing that you can do to kind of help you maintain your status is to keep very detailed records of anything that's related to your F1 studies. So if USCIS asks you to prove that you maintained full-time enrollment, again, it's not going to be enough to show them your I-20. It's a good idea to keep all of your diplomas, your completion certificates, transcripts, enrollment letters, attendance records, receipts for purchases of books, of tuition, even things like your course syllabi or your books and study guides. I mean, it may seem silly, but these documents can go a long way to prove that you have actually maintained status and you attended school full time. And it's important to keep the originals when possible. Sometimes copies are enough, but a lot of times they may not be, so make sure that you have your original documents. When you're asked to prove, compliance with your OPT or CPT, make sure that you have copies or originals of your employment offers, right? It's nice to have an offer letter with a job description showing that that job actually meets, that's related to your major, to your field of study. But also things like pay stubs and W-2s and tax returns, employment verification letters from your employers that specify the date when you worked for them, what your position was, and what your duties were. And also, review these documents. Don't just file them away, but review them when you get them. So, for example, your pay stubs, check the dates, check the hours. Your pay stubs, your pay period should match what you are authorized to do, right? So if your OPT starts on, August 15th, your pay stub should not show that you got paid as of August 1st. Or if it's CPT and it's part-time CPT and you're allowed to work only 20 hours a week, make sure that your pay stubs reflect that. It should be 20 hours or less, not 20 and a half or 25, because even that half an hour, that's shown on your pay stub could cause an issue and could be considered a violation of your status. That's how strict USCIS is. Big thing, evidence of how you supported yourself during your F1 when you were not allowed to work, when you did not have paid CPT or OPT. We have gotten many RFEs lately from USCIS asking for proof of how you financially supported yourself during your year to 5, 10 years of studies. So that really depends on your individual situation, right? If, for example, your parents were sending you money, make sure you have copies of all the wire transfers. Make sure that you have bank statements showing the deposits of those wires into your account. If you were using money from your bank account back home, your own savings, again, make sure that you have proof of both accounts in your home country and also here in the US, showing that you transferred your money from your foreign account into your US account. If you had a sponsor who helped to support you, again, it's not enough to show an I-20 saying, oh, look, I had a sponsor, that's how I supported myself. They actually want to see canceled checks that the sponsor issued to you. Or if the sponsor paid directly to the school for your tuition, they want copies of those canceled checks. Basically, anything that you can prove where the money came from, may be important in the future when you apply for a change of status or a green card. So you really have to be prepared and ready to convince USCIS that you maintained your status throughout the entire duration of your student visa. If you can't prove that you maintained your status, or if USCIS finds any violations of your status, not only will they deny the benefit that you're asking for, but they may put you in removal proceedings, right? And obviously we don't want that. I do want to throw a little caveat in here. There are exceptions for spouses, parents, and children of US citizens. So, if you happen to be a student who falls in love with a US citizen and you end up getting married, and that citizen then sponsors you for a green card, you may not have to show maintenance of status. It may be forgiven that you violated your status, but it's a very narrow exception. And in most other circumstances, it will be important to show your maintenance of status. There's kind of one bright spot that I want to mention when it comes to students, and that's the current status of the unlawful presence memo from 2018. We don't really have time to go into all the details and all the background on this, because that would probably require a complete separate panel. But I do want to mention that the 2018 memo that kind of changed the interpretation of unlawful presence and how it applies to students, that subjected students to a 3- and 10-year bar if they have violated their status and were now unlawfully present, is no longer in effect. On February 6th of this year, the judge did issue a permanent injunction that blocked the implementation of the memo. So as of right now, we have kind of gone back to the old policy that states that students do not accrue unlawful presence if they violate their status, which means they're not subject to a 3- and 10-year bar unless somebody specifically issues, like a judge would issue a specific determination that the status has been violated. But that's not a green light for you to go ahead and start violating your status tomorrow for a couple of reasons. One is that again, it's very difficult to get you back into status once you have violated it, even if you don't have unlawful presence. And other than marriage to a U.S. citizen or some other narrow exceptions, there may not be anything that you can do to obtain a green card in the future. And two, we don't know that this decision is final. The government can always appeal, right? They can appeal this decision, or they can just come up with a new set of rules that's similar to this and then find a different way to implement them. So this may not be the final word on this. So at all costs, maintain your status. That's a very important thing. Don't rely on what the government may or may not do. Okay?
That's great advice. Thank you, Renee. Yeah, I think, as we talk to students at our campuses and international students overall, sometimes there's a lot of confusion in terms of, well, can I do this, can I do that? Sometimes, I hear, well, the attorney said I can do this, but I'm not really sure. So it's always good to seek several opinions, I think, right? I know some students I think everybody is aware that CPT is something that's a very important process and needs to be managed really well. But I found out that maybe not all international students understand that volunteer work, even if it's unpaid, is considered CPT as well and needs to be approved. So always ask. I think there's, I've seen a couple questions come through. Well, can I do this without asking, or can I do this? Yes, probably, maybe, but don't. I think the advice is ask, right? Measure twice, cut once. Isn't that what they say? Right? So ask and make sure you have all the information and look things up. I think that's great advice. Thank you so much.
Okay, so I'm going to be speaking a little bit about CPT and OPT, some of the fundamentals and the key differences between the two. So let's just start with the basics. Well, CPT, the key word here is curricular practical training, right? So curriculum inherently means it's part of your curriculum. There's an academic pursuit or reason associated with the CPT, right? So logically, this is pre-completion, right? Before you end your program, which is distinguishable from OPT. But this has to be related to your program or field of study. You need to be getting it either is a requirement for the program or you're getting some type of academic credit for it, right? But it is directly related to what you are studying. And I think OPT as well. OPT is also related to your field of study or your coursework. But the thing with CPT is that it is always pre-completion because it is a required part of the curriculum or you're getting credit in order to finish your program. So then moving on to OPT, I think a misconception is that it's always post-completion. And that's not necessarily the case. So for OPT, this is optional practical training, and it can be either pre-completion or post-completion. I don't want the word optional to confuse anyone because this still must be related to your field of study or to your course work. So optional is not so optional, right? It needs to be giving you some type of practical training in what it is that you are studying. Both CPT and OPT require a year of full-time enrollment prior to seeking the practical training. Now, a year means different things. Generally, that's considered 9 months. I mentioned both must be, directly related to the coursework or your field of study. Both are limited to 20 hours or less during school. You can go full-time during summer or, of course, post-completion OPT. I think a common question is what status are you in? You're still in F1 status with both CPT and OPT, regardless of whether it's pre-completion or post-completion. You're not given some other status. So to dive a little bit deeper into CPT, CPT is offered through an arrangement between the prospective employer and your school, right, and your academic program. So this does require some, job offering before you apply. Again, this has to be approved by your DSO, and that's when they're really looking at, okay, what is it that you're studying, what is it that the job responsibilities are going to be, and how does this match up and provide the relevant training that you need to complete your program, okay? Because of that, in CPT, you cannot change employers post-application, meaning that if you wanted to change, it would have to be, a different employer, a different field of study. That's different from OPT, so we can talk about that in a bit. If you do change employers, it requires a new I-20. And generally, you should apply at least 2 weeks before your intended start date. That's like cutting it really close, right? I'm always going to say the sooner the better. There is no work authorization that's issued, so you're not applying for an employment authorization with CPT, right? That authorization is granted to you through the I-20. A big important thing to know here is that if you do work with CPT full-time for 12 months, then you do not later have the option for OPT, okay? However, if you're working part-time, which is 20 hours or less, then the 12-month, then it doesn't matter if you're working for a period of more than 12 months with CPT. I have written here in my notes something that was already touched upon, but it is really important that even if it is unpaid, even if this is a volunteer opportunity, right, that this is still submitted through your DSO as CPT. You want to be able to put this on your resume later, right? You want to show that it was pre-approved. You also want to prevent any type of ambiguity, right? You want to provide clarity that this was a volunteer position. Imagine later it becomes a paid opportunity and you do apply for CPT. There's always going to be a question of, well, was it really unpaid at the beginning when you were a volunteer, right? So let's clear up any ambiguity from the get-go. If it's a volunteer position, you do want that CPT authorization and pre-approval from your DSO. So that's kind of the basics about CPT. And I'm going to move on to OPT, which is, there's a little bit more to talk about with OPT. So again, this is the optional practical training, but it's not so optional, right? In the sense that what it is that you're doing, it's not up to you to decide to work at a bakery when you're studying being a dental hygienist. It should be related to your field of study. Now, unlike CPT, you do not need, though, a job offer prior to applying for OPT. Okay, you can change employers, but of course it must always be related to the field of study. Both pre and post completion OPT do require a work authorization. So that I-20 that it was allowing was allowing you to work for CPT is not enough for OPT. You do need to actually submit an application for work authorization, which means you do need to pay a filing fee as well, and that's $410 right now. Pre and post completion OPT are only available for a period of 12 months full time. And so and that's cumulative, right? And so what that means is that if you are doing pre-completion OPT part-time, so 20 hours or less, basically 2 months of part-time work are going to add up to 1 month counted against your 12 months of OPT that you're allowed, if that makes sense, okay? This can be used in chunks. OPT can be used in chunks, meaning, you want to do 2 months during the summer and kind of break up your 12 months. 2 months pre-completion, Post-completion cannot be broken up, but pre-completion can be broken up. But that does require a new application every time, a new filing fee every time, because they're different practical trainings, right? And they're different time periods, because on your employment authorization, and when they're reviewing that, they want to make sure that you were not employed, in a time that you were not supposed to be working, okay? So post-completion OPT, these, again, it's a 12-month period less any pre-completion OPT that you have completed, right? So they're gonna subtract that. And that's at every level of study, right? So what that means is you're granted 12 months OPT maybe for your field of study in your bachelor's, and then you can do another 12 for your master's or doctorate program, okay? Post-completion is full-time, meaning it must be more than the 20 hours. When to apply? Okay, so you can start to apply as early as 90 days or 3 months before you finish your program. But in no event may you apply later than 60 days after you complete your program. Okay? The start date is always going to be either date requested if it's 60 days after you complete your program, or whenever the employment authorization is adjudicated, okay, whichever of the two is later. But if you do start your 12 months, let's say 60 days, after you finish your program, under no circumstance may that extend beyond 14 months after you finish your program. I hope that makes sense. We'll take questions afterwards.
Just as a point, we do only post-completion OPT.
Oh, okay.
At CSI, but maybe other schools,
okay.
Do it as well for, the pre-completion, like you mentioned.
Okay. So then we'll just talk about I'm on the post-completion, so it's for you guys. Then it's going to be 12 months, unless of course you had CPT full-time for over 12 months, right? And that'll prevent you from seeking the OPT. You cannot change your intended start date of OPT after it's been approved, okay? You can cancel it or change it prior to approval, but after that you can't. Also, there's a possibility that you lose your OPT, your work authorization, if you are unemployed for a period of 90 days or more. There are some caveats to that that I can talk about in a second regarding the STEM extension. But generally, you want to make sure that you are working in your field of study at all times, and at no point are you unemployed for more than 90 days, okay? It is the student's responsibility to inform the school or the DSO of any change in activity, right, in order for SEVs to be updated, as well as any change in employer, okay? Because you don't need, unlike the CPT, you don't need that employer to be identified prior to applying. Once OPT has completed, you're granted a 60-day grace period, right, to either leave the U.S. or do a change of status or whatever it is that you're going to do later. There is an extension for some OPT, for some students that might qualify with a STEM degree. So that's science, technology, engineering, and math, right? So if you have a bachelor's from a accredited, U.S. institution, educational institution in a STEM field, then you can apply for an extension of your OPT. It's a 24-month extension. You have to apply before your initial 12 months are done. And if people have questions about this, I don't want to spend too much time about it because I don't know how relevant that is, but if you have questions about it, we can talk about it later. The one thing to note about the STEM extension is that it does extend your period of unemployment, meaning instead of 90 days of losing, your OPT if you're unemployed, it extends it by 60 days. So it's 150 days that you're basically allowed to be unemployed without losing that OPT. And then I don't know if Hugo was going to talk about the cap gap.
A little bit, but go ahead.
Well, just basically, if you do have an employer that is filing for an H1B or a change of status, and you do that before your F1, either your F1 status expires, or if you have F1 and you're on OPT, then that will be extended till September 30th, assuming your start date is, of course, October 1st for that H1B. So even if you're running out, if it ends during or before your start date, as long as it was applied for prior to your OPT ending or your F1 status ending, then it will automatically extend it until September 30th. So I think that's pretty much it.
Thank you, Jennifer. Yeah.
Alexandra.
Alexandra, oh my gosh. I'm looking at a name Jennifer here. And I,
So I hope, I'm happy to take questions later, but I hope that covered the basics.
That's really helpful. I think a lot of our students have questions on CPT and OPT. I've seen some come through, so we'll talk about that and kind of see what you guys have to say as well. Just really quick reminder that, and I've seen this question asked a whole bunch of times, we will post this webinar for anybody to review later on as well. So that will be available.
Boy, each one of these
Thank you,
topics,
Hugo.
each one of these topics could be a whole afternoon talked about. So it's a lot of information to pack into a short amount of time. So thank you for staying engaged. And along those lines, before I talk what I'm going to talk about, can I get a quick show of hands just so I know who's in the room? How many of you guys have a bachelor's degree? Okay, masters? A few masters? Okay. And just a quick, if you could shout out what countries are represented here. Just a few. Ukraine, Romania, Brazil, Pakistan, Mexico, I can see by that. Chivas? Yeah. No? Okay, never mind. Never assume. That's one of the lessons you should take away from this. Anyhow, what I want to talk about a little bit is a change of status. And I think if you're going to walk away from this presentation with any quotes, I think probably the most important one you've heard today is ask before you ask, because ask before you act. Is that right? That's right. Okay. Why? Because that friendly reminder is going to serve you well whatever status you end up having here in the U.S. It of course works on the F1 status, which I assume all of you are in. But it also is going to work for what I'm going to talk about. What's next? You're an F1. You've completed your studies. You did everything you're supposed to do. And you're looking at how do you stay in the U.S.? Can I work here a little bit longer term after completing my studies? The answer is yes. And there are a couple different ways you can do that. There's the most common way that most folks in your situation follow, which is the H1B program. But there might be a few other avenues available depending on what country you're from, and depending on what kind of resources you have on your own to bring to bear. So if we're going to talk generally about changing status, the most important thing to remember in order to achieve a successful change of status, meaning changing from an F situation, F1, to an H1B potentially, the most important thing you have to remember is you need to be in status to change status. You need to maintain your current status in good standing before you can apply for a new status. Okay? Otherwise, it's not that what you're applying for can't be done. It's that you won't be able to do it here. So for some reason, from what I'm talking about, if you want to become an H1B worker somewhere, if for some reason you haven't maintained status, it doesn't necessarily mean you can't get H1B. It just means you can't change here. It would probably mean you'd have to leave the country and convince a consular officer in your country to give you a visa to come back. Much more difficult proposition. So in order to avoid that, if you're in status, just remember, if you ask before you act, maintain your status, it's much easier then to change to another status that will allow you to continue working here in the U.S. or to continue to be in the U.S. and potentially work. So the H-1B program is the path that most F1 status holders follow to be able to extend their stay in the U.S. What is the H-1B? The H-1B is a temporary non-immigrant visa, and I'm not going to get into the difference between immigrant and non-immigrant, but it's a temporary visa that allows you to work for 3 years with a specific employer. Now, could that be any employer? Could it be any kind of job? No. The main requirement for an H-1B is that the position has to be a specialty occupation. Well, what does that mean? Specialty occupation is an occupation that requires at least a bachelor's degree in a specific field. The employer has to have an offer for you for a job that requires that degree, and the employer has to be willing to pay the prevailing wage depending on the type of position, depending on the experience required for that position, and depending on where the position is. Now, the employer doesn't have to go out there and prove that they're a common misconception, because this conflates with getting an immigrant visa based on employment, is that employers sometimes think, and sometimes students think, that employers have to go and prove that there are no U.S. workers who are willing, qualified, or able to take this position. That's not a requirement. But employers are required to pay at least the prevailing wage for that position at the experience level required in the location where the job is going to be offered. Okay? So, and it requires the employer to do some lifting. It requires the employer to sponsor you, to offer you a job, and to apply when the opening is to occur. So the employer needs to be heavily involved in this process. And in fact, the application process is commenced and carried forward by the employer. You are merely, in this process, you would be merely the beneficiary. It's the employer's petition. So it's kind of out of your control in some ways. The good aspect of it is that the employer can't pass the cost of doing this process onto you. The employer has to pay for it. So some important things to remember about the mechanics of how the H-1B works. There's way more demand than there are H-1Bs available. We have 85,000 H-1Bs available, 65,000 for anyone who has a bachelor's degree, and again, bachelor's degree in specific occupations. And there's 20,000 set aside for people who have a master's degree in the U.S. If you have a master's degree and you're in the U.S. and you have an opportunity to be sponsored by an employer for an H-1B, your chances of getting one of these visas is much greater, especially now with how they're doing the lottery. And I jumped my space a little bit. There's a lottery because there's more demand than there's supply. There's a lottery. I'll get to that. But if you're one of the 20,000 people chosen because you have a master's degree, there's a much greater chance, because of how they do it, that you're going to get one of these. Now, more demand than their supply. How do they determine who gets these H-1Bs? Well, every year you have to apply 6 months, at the earliest 6 months before the start of the fiscal year. What's the fiscal year for the government? October 1st. So that's why the magical date for H-1Bs had been, ever since the program was instituted, April 1st. So March and heading into that April 1st deadline, immigration attorneys who do H-1B cases are frantic, right? This year it's a little bit different. It's a lot different. But the bottom line is, you can't just show up in September to an employer hope to get an H-1B petition approved. It has to be much sooner, much earlier than that. Now, April 1st was the traditional deadline to file these. What's the situation? And so you would file them. Every application received within the first 5 days of April then would go into some giant algorithm, and USCIS would pick out enough applications to satisfy the 85,000 that they needed for that year. Okay? So you had to file everything on April 1st, between April 1st and April 5th, and then you'd get your 85,000 magically that way. That's not the case anymore. We are in the midst right now of something called an H-1B registration period. What does that mean? The government is now requiring employers to identify who they might want to sponsor, and before inviting people to actually file a complete H-1B packet, they're requiring them to pre-register, pay a $10 fee, register online at USCIS with the company and the potential employee between March 1st and March 20th. On March 20th, or shortly thereabout, there's going to be a lottery, and they're going to pick as many cases as they feel are required to fulfill the 85,000 quota for this year. And so what does that mean? It means that starting April 1st, all of those selected in the lottery in March will have 90 days to prepare and file their H-1B applications. Okay? So, jury's still out. It's theoretically, it sounds more efficient. It sounds like it could be cheaper for employers, but we'll see. We're in the middle of it. So far, it's working kind of smoothly, I think.
Yeah.
Yeah, a little cumbersome, but in any event. So what that means for something like a cap gap. What is a cap gap? Again, it's mentioned just a little bit earlier. If you have OPT that ends before, again, the magic date for an H-1B. An H-1B is not going to be valid, even if you get selected, is not going to be valid until October 1st. You graduate in May. Your OPT ends in June. What do? There's a 3-month gap. Well, the solution is if you have an H-1B application filed and accepted before your status expires. Status expiration meaning either OPT ends or your time at school ends. And you can show that at the time you have the application, you had the requirements to file the requirements to file an H-1B. You have to have your master's or your bachelor's degree already in hand when you file that I-129. The I-129 is a form to file the H-1B. As long as it's filed and it's accepted, USCIS will extend your status up until October 1st, meaning you can continue working up until that time. So so in that gap, in however many months that is, theoretically, USCIS is supposed to decide on your case so that when October 1st comes, you magically then become an H-1B. That doesn't always happen. If your case is still pending on October 1st, you may have to stop working on October 1st because you wouldn't be allowed to work until you have an H-1B. You would still be allowed to stay here because you'd be in status pending the approval of an H-1B that's pending. In any event, the reason it's important in this context, the new world of the H-1B lottery, is that when you prepare your registration now in March to be in the lottery, you have to be able to tell the government that the registrations were filed in good faith, meaning the people that were putting forth in the lottery have all the requirements. But there's a little leeway if you can say maybe they didn't have the requirement in March, but they will have the requirements by the time we file the I-129 later on that year. So once a lottery happens, employers are going to have between April 1st and June 1st. That's 90 days, right? Actually, July 1st. Thank you. I can count. Hopefully in that time, people will graduate and things like this. So they'll have degrees in hand. In your case, that wouldn't matter because you either have, this is a certificate program. You have to have a degree program. You would have your degree required for this in any event. That's the basics of the H-1B scheme. There's much more to it, but at least it gives you some sense of what the timing is. And if you're thinking about a job that could lead to an H-1B starting in October of 2020, that you should probably be acting now.
It's good advice.
Got 9 days. Got 9 days.
Thank you so much, Hugo.
Yeah.
Thank you to all of our panelists. You guys were really informative, and I appreciate that, so thank you. Amazing information and a lot of questions. We've been getting a lot of questions online, and I don't know if we're going to get through, even most of them, but let me kind of start off with one that I've seen that I think is kind of relevant for today, especially, and asked in kind of different ways. First of all, it's about travel abroad, and spring break is coming, right, here at CSI and a lot of colleges and universities, and students are asking, well, do we need to get permission to leave for spring break and so forth? Should we see the DSO? I think we all got the answer is yes. Come see us before you travel. But in general, traveling abroad for international students, and one specific question was, if I'm on OPT, can I travel abroad? Is anybody want to address that specifically, just in if you're on OPT status about travel?
Well, you may be allowed to travel, but remember, to travel, you actually need an F1 visa stamp in your passport, right? So it's not enough to have an I-20, it's not enough to have your OPT card. If you're going to travel abroad and you don't have a valid F1 visa stamp in your passport, you won't be able to return unless you go to the embassy and obtain a visa stamp, which may or may not be possible depending on how the consular officer views your case and whether they think that you will be in the US temporarily, whether you intend to go back to your home country, or you're going to be changing status to an H1B. So it is risky, especially because you're already in OPT, you're no longer studying, right? If you don't have a valid F1 visa, I would advise against traveling, during that period of time.
An important point you brought up. The F1, of course, is not a dual intent visa. What does that mean? It means that you have to prove to the consular officer when you first get your visa and to the CBP officer who you meet when you come in at O'Hare or wherever.
Or Logan for Massachusetts students.
Right. That you intend only to come to study. And they have to be convinced of that. Most of the time, it's not a problem, but sometimes it is. And if you've been here a long time, if you've had CPT, if you have OPT, in any event, that's an important aspect of the F1 visa to remember. Now, the H1B, one of the benefits is if you are to get in a situation where you can have an H1B visa, H1B is nice in that it's a dual intent visa. It's meaning they can't deny you access to the benefits of an H1B merely because you may have the intent to immigrate. So that's an important benefit as well.
That's important. Sure.
Okay, my question is, and I just heard this on the radio this morning.
Yes, thank you.
I just heard this on the radio this morning, that they may extend the time for the tax past April 15th because of the coronavirus situation. Has that come up at all in any of the OPT, CPT, H1B, or any of these, or traveling abroad where so many things are canceled now? That's why I'm asking. Has that come up?
In terms of filing
Of
taxes?
dates and, no, in terms of dates, have those changed at all yet? Your dates are still
nothing
set?
official.
We've only, from a personal level, I've only experienced it in the negative. Dates, immigrant visa interviews, non-immigrant visa interviews canceled with no reschedule.
Okay.
So far there hasn't been any positive accommodation, if that's what you're getting at.
Yeah, that's what I was wondering,
Yeah.
if there was anything. Thank you.
Thank you. Do we have any other questions from the audience? Okay, fantastic. So the people in the audience outside of here can hear you. That's helpful.
Hi.
No, it's only for, it's not going to amplify here. It's for the...
Yeah. So I have a question. I'm about to change my status. I just got married.
No. You need it because it's for people who are logged in
Okay.
on the internet.
Yes.
So I just got married about 3 weeks ago. Then I didn't
Congratulations.
file anything
Congratulations.
yet because I'm in the middle of moving. And next month, I'm supposed to pay the tuition for the next quarter. So my question is, if I'm filing my paper about changing my status, do I still need to register my next quarter?
So this is marriage to a U.S.
US.
citizen? Okay.
Which is like 2 weeks.
What are you supposed to do?
Well, let me know what a lot of students have
can-
questions like
right.
that.
So,
Yeah.
there's the safe route, right? And then there's the little bit of a risky route. So, the safest approach, the best advice would be to maintain your status until you actually get the green card in hand, right? So that means pay your tuition, continue to attend school. That's the safe approach, that's what would be recommended. But I also mentioned before that you're not required to maintain status if you're obtaining your green card through marriage to a U.S. citizen. But things could happen. I mean, I know you just got married, and I'm sure it's going to be a long, lifelong marriage and things like that. But, what if something happens? What if, the marriage breaks up? What if there's the new public charge rule, right, that we didn't even get into?
Lawyers always have, like bad news.
Right. I mean, that's what we get paid to, right? To come up with all these negative things.
Just to give you information.
So there's a little bit of a risk that you would take if you don't maintain your status. It's probably a little risk, and you're probably okay doing it. But again, the safest approach would be to just re-enroll.
Right, because there's an assumption that it's going to get approved, right? And at that point, then they will forgive that period where you were out of status, right? But there's always the possibility, and for whatever reason, right, things don't go as planned, and then you can't go back and say, actually.
So better safe than sorry, right?
Right, so.
Thank you so much.
I mean, especially with the new public charge rules, it's a very extensive set of questions, and it's also a very broad avenue for USCIS to find new ways to deny cases, as far as I'm concerned. So, especially because of that, the advice to be conservative is probably the best route to take.
Yeah.
Thank you.
Following my question is, my friend had the same situation. She was a student when she was in the U.S. And then she married an American citizen, and she hired an attorney. And she told me as long as I file my paper and I get a receipt, so I can have a little bit gap time before my working permission get to my hands, that I can prove that I have a proof that I will extend my status until is there a visa called K1? Like,
Yeah,
It's for
the
fiancés, so that no longer applies to you. If once you're married, you don't qualify for a K1.
Yeah, we finished pretty fast. So we just so but like my CPT and this year my program will be end by July. So like right now it's March. If I file my paper until July, if I get my receipt, do I still need to extend my school?
Well, if you're in CPT, yes, right? Because CPT, as we spoke about, was, part of your curriculum. So certainly you can't be in school and enrolled in that curriculum and still be doing CPT.
Yeah, but this year program gonna be finished by July.
So maybe, some of those kinds of questions will be great if you address to the DSO, because they can specifically answer that.
Yeah.
But the general question is, keep my F1 visa while I'm changing my status or not? And in some cases, it's riskier than others.
Well, and then
I suppose.
you have to also think of it from the other side too. If you let your F1 go and you're employed as a CPT, then
Well, that ends. That ends.
Right.
Yeah.
I mean, you would if you want to continue working, I guess you could, but the employer would no longer lawfully be able to employ you.
Yeah, then
So that's an important aspect to think about as well.
Yeah, good
that I
stuff.
will get it solved.
Yeah.
Any other questions? Yes. And we only have about a little less than 10 minutes, so we're going to try to get through a bunch.
Okay, so I completed my MBA a few years back and got an OPT approved. And now I'm in a certificate program. And my question is, if because I'm not allowed to apply for OPT for this program that I'm in, but I can apply for an OPT once I'm done with this program. Now, is it possible, because I already got approved on MBA, which was customer experience manager, is it possible to get approved if I file in for OPT after done with this program? Or do I have to do an higher program to get approved for an OPT? Is that the case?
So you just answered your own question.
Oh,
it has to be a
I
higher.
wasn't too sure because
It does.
yeah, and the question was because I did MBA, which was in something different from the field I'm in right now. It was like in medical. This is close to the health program, and the one I did in MBA is not related to what I'm doing right now.
Right,
So I
but it
wasn't
is
sure.
one OPT at every degree level. Right. So regardless of kind of what that
The
field of
industry
study
that-
is, it is one at every degree level. So her question was if she had OPT through a master's program, if now she's in a different program but it's not a higher degree, if she can seek a new OPT, and the answer is no, you're allowed one per kind of level.
Thank you.
We had a quick question online, which is, can an OPT holder have unpaid employment, volunteer, since there's only 90 days allowed to find a job?
Actually, it's a good,
It's a good question, right?
You have to have full-time employment, right? And so
But
I
will
would
volunteer
say-
work while you're an OPT? It's still employment.
say-
so probably
do you
no.
have an answer? I would say no.
Well, you have to be very careful in terms of volunteer, because there's also Department of Labor, I think, rules that go into
Right.
play here. You're not allowed to usually volunteer if it's traditionally not a volunteer position, you know. So, you know, if you're volunteering at a church, you know, that may be one thing. If you're volunteering at, you know, McDonald's, that may be
Corporate
another thing,
headquarters,
right?
maybe, right?
So you have to be very careful about that, because there's other rules, you know, that
apply.
play here.
I mean, generally, if you're
Right.
volunteering at a position that normally gets paid, it's
Right.
not a volunteer position.
Right, if it's clearly to circumvent the 90-day unemployment, then the answer is probably no.
And then one other quick question about OPT and employment. While on OPT, can you own your own business, run your own business?
So you can be self-employed.
Self-employed, yeah.
On OPT, there are some kind of specific rules about that. I'm not super familiar with the self-employment regarding OPT. I don't know if either of you are.
I think a good idea would be to actually incorporate, to register your
Right.
business, because how else are you going to prove that you're self-employed? So it would be good to actually incorporate. I think that's a pretty easy process, or, you know, somehow register your business so you have some proof that you are actually self-employed.
Right, and you do have to reach that full-time level. So let's not forget, you know, if you're just a musician on the side or whatever it is and you're doing gigs, I mean, you have to show that you had full-time employment. This was a full-time job, right? Even if you are self-employed.
Thank you so much. Okay, I know we have some more questions.
Okay, it's working.
Yeah.
Okay. I took the CPT program. I completed, and but it was full time, but it wasn't more than 12 months. So it was like 11 months and a half, something like that. Can I apply for an OPT?
Well, in theory, right, the answer would be yes, because it's not to exceed 12 months. But again, that's when your paperwork and having everything in order is really, really important, right, to document that you did not exceed that 12-month amount of full-time CPT.
I also believe that if you are a part-time CPT, you may be eligible for OPT, but full-time
Right.
CPT you would not be. But I'm not an attorney.
Full-time for 12 months or more.
Yeah.
Right. But part-time for more than 12 months is okay.
Okay, but I did full time, no
Right.
part time.
Full-time
But
you
it
would not
wasn't
be
more than
eligible for
12
OPT,
months.
my understanding,
If you exceed 12 months.
even if you don't.
Right.
Because the CPT cannot exceed 12 months, right?
Right. But she
Okay. It's a good question. I think we're going to have to think about that one.
Okay.
I would like to ask about the work visa. Do we only have one chance this year to apply until April 1st, or or there is more time
Yeah, no, to this year,
Yeah.
and this is depends on how many applicants we get. I don't think there's any chance. It's unlikely that we're gonna get fewer applications than are needed to have the whole quota. So this year, if you want to be in the H-1B program, you basically have to find an employer who's going to be willing to hire you and is going to be willing to register within the next week and a half.
Which is very difficult.
Very difficult.
Yeah.
I will say this though.
I mean, my question is mostly, do you take more applications or
Well,
first? If you-
let me complete the thought then, because of that question. So that only applies to employers who are subject to the cap. What does that mean? Most private employers who want to participate in the H-1B program are subject to this 85,000 visa cap. If for any reason they can be outside that cap, then they don't have to comply with the timelines that I talked about. How are they outside the cap? It's either because of something you did before, or it's either because of who the employer is. If you've ever been counted against the cap once in the last 6 years, then you wouldn't be subject to the cap no matter where you went. If the employer is an academic institution or does work associated with an academic institution, they wouldn't be subject to the cap, and they could potentially file an H-1B at any time for you. But most of the, and sometimes private employers can avoid the cap if you can find, if there's some relation that they have with academic institution. Most of the time it's pretty clear, but you'd be surprised. Sometimes there are relationships with bigger employers that aren't obvious at first sight. So.
Okay, well, we have time for like a super quick question, if anybody has one.
Hello, my name is Fabricio. Recently, in 2018, I attended an OPT program here at CSI. Last year, I worked in a company in Michigan by OPT program. My OPT program got expired in February 10th. And now I'm a CPT applicant. I've gotten a new job in another company, and now in April I'll restart the program and my work. My question is not I'm not able for apply to H1B visa in addition to CPT program. I'd like to know if it's possible to for me apply.
To do both at the same time?
Yes.
Yeah, I mean, you would be applying to change status from F to H, but until the H gets approved, you're not an H, you're just an F. So you could be an F, and if you could find an employer that's willing to at least ask an application is basically the employer asking the government, hey, can you change him from F to H so he can work here?
Okay.
While that question gets answered, you're not an H, so you can be an H. And in fact, it's probably better that you be in F, because you remember what I said at the beginning. You have to be in status for you to be able to change status. So, yes, I mean, you could do both. But again, I mean, it's be difficult this year.
Okay. In addition, you said H1B must be applied by the company, by the employer.
Yes.
Yes, I can apply by myself.
No.
Okay. Okay, thank you so much.
Okay, thank you so much, everybody. Thank you. This was a great opportunity for us to hear some great feedback from some local attorneys and learn a little bit about laws and rules and regulations. And we hope to be bringing these kinds of seminars to you a lot more often and in your campuses. And so we loved your feedback. I got so many questions. We're going to try to kind of get through them. We have some of your names, some of you are students. If you're not a student, please go ahead and send us your email, and we'll be able to respond with your name through the way you submitted it, so we can respond to you personally. So thank you very much, and have a great day. Thank you.